were in Ionia, Michigan for a sentencing. 61-year-old Cheryl D. Morgan has pled no contest to driving under the influence and assaulting or resisting a police officer. 3 months earlier, Morgan, who already had 3 prior DUI convictions, was pulled over and asked to take a field sobriety test. But police say Morgan was uncooperative and allegedly threatened officers, even kicking one in the shin. She was arrested. Later, a blood test revealed that her BAC was 0.18, more than 2 times the legal limit. Morgan was also initially charged with driving with a suspended license and having an open container of alcohol in her vehicle, but those charges were dropped as part of her plea deal. Today, she appears before Judge Ronald Schaefer to hear her sentence. The state, represented by Kyle Butler, is asking for a sentence of 150 days in jail plus probation. But first, Judge Schaefer checks in with defense attorney Karen Constantine, who argues that her client cannot serve jail time because of medical issues, including respiratory problems and nerve damage in her back that requires surgery.
All right, Ms. Constantine, elocution on behalf of your client.
Yes, Your Honor. Miss Morgan has so many health problems. My biggest issue is CPAP. If you don't use the CPAP, then you stop breathing. The jail does not allow that. I've already called them and asked them. So I am asking this court to place her on a tether for whatever, 90 days, 6 months, but she can't walk. She has nerve problems. That's why I'm asking the court to put her on tether.
Before making a ruling, Judge Schaefer wants to hear from the defendant.
Then, Ms. Morgan, did you have anything that you want to state to the court before a sentence is imposed?
I'm sorry for everything, but I don't want jail because I have to go set up surgery for my back or I won't be walking. And he just put plates in my neck.
You have 3 priors. Your bodily alcohol content was 0.18. I do not have faith in you. And I'm not unsympathetic to your physical conditions. Your physical conditions did not prevent you from fighting with the officers, pulling your arms away, making a fist, telling them that I'm going to kill you. Your physical condition didn't prevent you from kicking an officer in the shin. Right? It's hard to buy when I hear today, Judge, boy, I just can't do any of that because of my physical condition, but I can kick a police officer. They don't go together, do they? But the fact of the matter is, here we are, 4th offense today. You're not interested in addressing your alcohol problem. You don't think that you have an alcohol problem. How would this court look when a 4th offense drunk driver gets no jail time, and then 6 months from now, and you kill somebody? Well, you can roll your eyes, but it happens every day. Ms. Morgan, I don't need to hear anything from you. You've already had your opportunity to speak.
And with that, the judge exceeds the state's recommendation, sentences Morgan to 13 months to 5 years in prison, plus $1,800 in fines and court costs.
File anything else from either side?
Your Honor, could you please discuss what we're supposed to do with the CPAP?
It's not the bailiwick of the court to instruct the jail or the Department of Corrections on how to manage the health conditions of their inmates.
Morgan will be eligible for parole after she serves 13 months. We head to Warren County, Ohio for the sentencing of Lance Runyon. The 57-year-old pled guilty to attempted aggravated murder. More than 6 months earlier, the husband and father was home alone when he sent an alarming text to his family, causing his brother to call 911. The brother asked police to do a welfare check on Runyon, who, as it happens, previously worked as a corrections officer. The visit's captured by a doorbell camera. There are several deputies outside, including 12-year vet Sarah Vaught.
What do you say? 482, she'll give you the garage code if she wants us to check on him. Here it comes. Here he is, here he is.
Runyon fired once at Deputy Vaught, but somehow she avoids getting hit. Not so for Runyon, who was hit multiple times.
Show us your hands! Show us your hands! Show us your hands! Hey, sir, you good?
I'm good, I think.
The deputies tend to the fallen Runyon. He was taken to a local hospital and survived his injuries. Runyon pled guilty to all charges and claimed he couldn't clearly remember the incident.
The state of Ohio versus Lance Runyon, we are present for sentencing.
At sentencing, Runyon's looking at a possible maximum of 23 years in prison. But first, the state plays a full recording of the incident, including a brief comment made by Runyon from inside just minutes before he opened fire. That was Runyon, who then waits another 2 minutes before finally opening the door. After this horrifying moment is played for the court, Deputy Vaught comes forward to address the judge and the man who tried to kill her.
I have dealt with hundreds of people in crisis during my 12 years on patrol. And Lance Runyon is the only one that has tried to kill me. But I did not survive unharmed. I was diagnosed with PTSD and went through months of treatment until my symptoms were under control. I am still healing and will carry the effects of this with me for the rest of my life.
Next, Runyon's given a chance to address the court.
I'd like to apologize to the deputy, the other officers. She just... I just don't remember much of it. Sorry that it happened. Not because I'm in trouble, but because for everybody. And I'm just sorry. Sorry to all of you.
Finally, after hearing Runyon's tearful apology, the judge gets the final word before imposing sentence.
Mr. Runyon, you cannot offer an explanation to the court as to why this happened. Obviously, I'm in no position to be able to try to explain it either. You did acknowledge your guilt. You do not have a prior record, so the court does take that into consideration. So the court is going to order you to serve a period of 10 years, a minimum term sentence in prison with a maximum term of 15 years.
In addition to the 10 years for attempted aggravated murder, Runyon sentenced to a minimum of 7 years for committing the offense with a firearm, for a total of 17 years in a state prison. We're in Eureka, Kansas for a hearing. 48-year-old William Wayne Phillips has been charged with speeding and driving with a suspended license. 3 months earlier, Phillips was pulled over for driving 86 miles an hour in a 65 zone. He was also cited for his second driving with a suspended license offense. Today, Phillips appears without an attorney before Judge Phyllis Webster to discuss next steps in the case. But before the hearing even begins, Phillips seems to have irritated the judge.
Yeah, William Phillips, did the officer tell you not to smoke?
It's kind of hard to hear around here. I'm out of town on a construction site, and I'm the lead, so...
Judge Webster lets the cigarette slide and moves on to the charges.
Mr. Phillips, are you going to be hiring an attorney, sir? You could waive your right, though, and represent yourself, and we can either set this for trial or give you some time to talk to an attorney. What would you like to do?
If I need an attorney, I'm not going to get one from you guys. That's most definitely.
Okay, so you're going to hire an attorney?
Yes, ma'am.
All right. Let's put this on Monday.
Can it be scheduled after that? I won't be back in this area for the next, 2 or 3 months.
You want to try to do it before you leave? When are you leaving?
I'm already gone. That's the
you're
thing.
already-
I'm in Independence, Kansas.
Well, that's not that far.
It is when I have to work. I mean,
All right, sir, I'm detecting a bit of an attitude, and I've had a bit of problem with you all day long. I suggest you kind of take a deep breath and try to get rid of the attitude, because then if you don't, you may cause me to have to get an attitude too. So,
take that deep breath, do the same thing. You know what I mean?
Excuse me?
I said same. Do the same thing. Take that deep breath. Goose fraba.
Some of the others on the call seem amused by Phillips' comments, but the judge is not happy.
All right, Mr. Phillips, do you know what my title is?
I do, but that doesn't give you the right to belittle me or anybody else in your court.
I am finding your conduct contemptuous because you're interfering and disrespecting the process and the court. You are hereby fined for direct contempt of court, $100 cash.
That's fine.
You've complained that you can't be here when I tell you to, that it's inconvenient because you're maybe a couple hours away. Some of these people are in other states. So don't tell
But that's
me.
not this case. That's not this case. This is my case, not their case.
Yes, it is. And that's
No, it's-
$200 for contempt. You better get a clue who's in charge here. $200, Mr. Phillips, due in court Monday, or you can serve 3 days in jail. I have found you in direct contempt of court. You owe the court
I don't owe you nothing. I owe the court and the state of Kansas. See, that's your problem. You're taking your own personality into your law, and that's not appropriate. Can we hurry up and get this over with?
$500 cash for direct court, and I am ordering you to surrender yourself by 2:30 today to the Butler County District Court.
I cannot do that.
Well, then
You're
I'll
making me-
send a sheriff out to get you.
I'm going to hire an attorney. I am going to get off this Zoom, and I want this sent to my email. And I demand this footage, because I'm going to take this and I'm going to appeal all of this. The whole time.
All right, I've given you my order. Disconnect him from the call. He better be here, or the sheriff will go out.
I will not be there.
Missy, disconnect
I was
him.
trying to reschedule it, so
All right, folks, let's move on.
Phillips failed to show up in court that day, and a bench warrant was issued for his arrest. After spending 6 days in jail, he was released on a $1,000 bond. His case is pending. We're in the Ann Arbor, Michigan virtual courtroom of Judge Cedric Simpson for a sentencing hearing. 41-year-old Natasha Mitchell has pled guilty to operating a vehicle while intoxicated. A year earlier, police found Mitchell outside a pizza parlor in the driver's seat of her car, along with a bottle of tequila. Her blood alcohol level was 0.119, well above the legal limit of 0.08. She was arrested and released on a personal recognizance bond. Mitchell is banned from drinking alcohol while out on bond and has been required to use a SoberLink portable breathalyzer for the past year. And while she's consistently had negative test results, she's recently missed some tests completely. So the probation department is requesting she be given jail time and upgraded to an ankle bracelet.
Okay, where are we on this one?
There was a request for 4 days in jail to report to the Washington County Jail today at 6 p.m. to get a scram tether placed on her.
This all seems to take Mitchell by surprise.
Please don't put me on tether. It's embarrassing enough to have to blow when I do. I've been blowing for probably, a year now. I have had some times where I've missed because of falling asleep or just simply forgetting. Lord have mercy. Please give me some leniency.
Miss Mitchell?
Yes.
How long have we been dealing with each other?
I don't know. It's been a long time, but I haven't seen you in a long time. It's been years since I've seen you.
Mitchell and Judge Simpson have history. She's appeared in his courtroom several times before.
Miss Mitchell, if it's been all that long, why do you think I remember you?
Because you always was saying how my face was looking mean or how I always look mean, but I smile now. I don't.
You always would appear before me with, you had a scowl.
I had an attitude. I had a very bad attitude.
Yes, you did. I'm glad you finally admit that. I kept telling you that.
That's the old me.
Let's see if we can get you through this, Miss Mitchell, okay?
With the reminiscing over, Judge Simpson turns his attention to the question at hand, whether or not to punish Mitchell for her missed tests.
So here's what I'm going to do, Miss Mitchell. I'm going to place you on 24 months probation. I'm going to continue on the sober line.
I appreciate it.
But you cannot miss any tests.
I will not miss any test.
I will not have her report to jail at this time.
I won't let you down. I appreciate you.
Miss Polera or Elin, if she even begins to mess up, come find me personally, because I'm going to get in my truck and we're going to go get her.
I will make note of that.
And she does not want me just rolling up on her, because I will.
I sure don't. I sure don't.
Mitchell's serving her 2 years probation, but she avoided jail time and remains on her sober lane. Judge Simpson has not had to deploy his truck. We go to a hearing in Ypsilanti, Michigan. 31-year-old Michael Carter's been charged with driving with a suspended license. He appears today before Judge Elaine Washington, who will determine next steps in Carter's case. But first, prosecuting attorney Kyle Bradell calls the judge's attention to Carter's surprising call-in location for today's hearing.
I do feel the need to point out he is in a vehicle. Mr. Bannis, you know if your client's in the back seat or if he's in the driver's seat?
Looks like the back seat to me, but
I suppose, Judge, if he could just turn his camera and show that he's in the back seat, that would be enough to satisfy me. I don't know if Mr. Bannis wants to instruct his client to do that yet.
Mr. Bannis, here, this is your opportunity.
Your Honor, if we could have a breakout room, then I think I could at least make some representations to the court about what I believe is going on.
When Carter and his lawyer return from the breakout room, the prosecutor notices something a bit different about Carter.
Judge, he's clearly in a different seat. The
prosecutor seems annoyed, but he'll still offer Carter a plea deal.
He can plead to no ops on person at this time.
No operator's license is a lesser charge, but it would still be added to Carter's driving record.
I got a question, ma'am.
Well, hold on, sir. I'm going to advise you not to say anything.
Okay.
Of course, there's no evidence that he's driving, but prosecutor has the ability to make whatever offer he feels is appropriate. So, Mr. Carter, if you want to resolve the driving while license suspended misdemeanor, you could plead guilty to a slightly less serious misdemeanor called no operator's license on person, which has 0 points. And I would ask the judge to sentence you to a fine. Are you interested in that?
No, I'm not.
All right, I'm going to adjourn all these matters to November the 1st. That is the last adjournment on this particular case. And at that point in time, your client will need to determine whether he wants to accept an offer or to set this for a trial.
Yes, ma'am.
All right, I'll see you then.
In the end, Carter's decision to reject the plea deal worked out, as the case was later dismissed by the prosecutor. Next, we go to Houston, Texas for a motion hearing. 42-year-old Christopher Bibaud has been charged with theft. 5 months earlier, according to police, Bibaud was fired from his job at a cleaning service for allegedly drinking on the job. And when he refused to return some of the company's cleaning products, he was arrested and then released on $2,500 bond. Today, Bibaud appears without an attorney before Judge David Fleischer to discuss next steps in the case.
Good morning. You have a lawyer today? No, sir, I don't. I don't think I need one. Forgive me for saying that, but the original police report decriminates me. Can I read? No. Okay, it's fine. You need a lawyer to represent you. Sorry, can't afford one. But if I can just explain, if you let me explain, can I explain the police report? Because it decriminates me, sir. I'll give you a lawyer today. Okay. Have you speak to the lawyer. The lawyer can give your side to the DAs, and then they can try to work something out for you, okay? So just hang tight.
Bibaud stands by, but it seems he's got some questions.
Be the prosecution. Sir, you're not allowed to talk. Okay. Because it literally decriminates me, sir. Okay.
Speak to the attorney when you get appointed.
Bibaud is told to have a seat and wait, but after a while, he gets up and walks towards the judge.
Have a seat. Have a seat, sir.
And a court deputy springs into action.
Have a seat. Have a seat, sir.
Take it. Can I get my car? No. I can't handle deeper? Are you joking?
Bibaud is removed from the courtroom, and the judge gets back to business.
It's Monday. It's Monday. Could be worse, though.
Later that day, Bibaud was returned to the courtroom, this time in cuffs with a torn shirt, and was appointed an attorney, Michael Slider. It seems Judge Fleischer has decided to give Bibaud a second chance.
Hey, how's it going? Good. All we want you to do, Mr. Bibaud, is give your side to Mr. Slider. Okay, he will help you work with this case so it can get the best result possible. We don't appreciate when people come from over there all the way over here because it's very possible that I didn't even see that you were here. I'm sorry, I didn't mean to sneak up on you. I'm sorry. The problem is that not everybody is as nice as you. What happens if someone comes and tries to attack me here? You know what I mean? I'm sorry if that's ever happened. So I didn't even see you and it scared the crap out of me. Well, I'm sorry, I didn't mean to scare you, sir, okay? If I thought you meant ill will, I would already have you in jail. Okay. Right. I appreciate you not locking me up, thank you. Of course not. I don't want to lock you up. I don't want to put you in jail. I don't want anything bad to happen to you. Just understand, we have a certain way that we handle things here. So just be wary that all I need you to do at this point is stay in contact with him. I mean, if you do, good things will happen for you. And one more thing, don't pick up any new cases. I'll try not. I won't. All right, please.
The judge released Bibaud on bond, and a month later, he completed a diversion program, and the case was dismissed.
I hope that no other family has to endure anything like we have had to. Christopher Griffey has completely destroyed my life.
We're in Idaho Falls for a sentencing hearing. 36-year-old Christopher Griffey pled guilty to felony domestic battery and attempted strangulation for violently attacking his then-girlfriend while high on methamphetamine. Griffey admitted to punching, choking, and threatening to kill the victim in front of her 7-year-old son. Now, before learning his punishment, the victim shares the lasting effects Griffey's traumatic abuse had on her and her son.
Can't express completely how mine and my son's lives have been adversely affected by this incident with Christopher. Christopher completely broke me down until I didn't even know who I was anymore. I have developed a fear of the dark that is so intense, I have to sleep with the lights on. When I go to sleep, I still wake up screaming or crying.
As the victim continues, it appears her words are having a profound effect on Griffey.
I could not understand why I was treated this way by somebody who made me believe that he loved me. I could not understand what I could have possibly done to have my son and I both deserve to have these things done to us. We trusted him. I put our safety in the hands of a man that I should have never been alone with. Christopher Griffey has completely destroyed my life.
Griffey then lets the court know he is not without remorse for the damage he's done.
I'm not a monster. I'm more than willing to face this, and you don't need to give me any less time. You give me as much as you feel you need to give me, and I'll go up there and I'll face it, and I'll get as much help as I can get up there.
More than just addressing his crimes, Griffey makes an emotional apology to the victim.
Apologies are such a sham. I'm sorry for how everything went. I couldn't keep my promise that all this time I wanted to say an apology.
And despite the horrific crimes perpetrated against her, the victim interjects and validates Griffey's feelings.
No matter what you're Mr. Griffey. Yeah, you're my best friend too.
Now with Griffey facing up to 25 years in prison, it's time for Judge Dane Watkins Jr. to hand down the sentence.
It's been an emotional sentencing, and I want you to know, Mr. Griffey, that the court watched you very carefully. You made some important statements of accountability and submissiveness to the judgment of this court, and I too feel the weight of this sentence. It is a dramatic thing that we're discussing upon your shoulders. I sense that from your comments. It's clear to the court that you have taken ownership, and the court pronounces on the domestic violence felony matter 2 years fixed, followed by 8 years indeterminate for a unified sentence of 10 years. On the attempted strangulation, 3 years determinate with 10 years of indeterminate time.
That means Christopher Griffey's sentence will be at least 3 years and up to 13. During that time, his parole eligibility will be determined by the state parole board beginning in 2023. We head inside the Fayette County Courthouse in Uniontown, Pennsylvania. 34-year-old Anthony Sheffey has been charged with aggravated assault by driving, possession of a firearm, fleeing an officer, and a number of other charges. A year and a half earlier, an officer tried to pull Sheffey over for a traffic violation. But the defendant sped away and a few minutes later crashed into another vehicle. Sheffey fled on foot but was quickly arrested. No one was seriously injured in the crash. Today's hearing has been postponed, but before Sheffey, who's free on bond, can leave for the day, deputies learn that he has a felony warrant for an unrelated DUI charge in another county. Officers escort Sheffey to an office while the sheriff signs the warrant. But before they can put the cuffs on him, Sheffey breaks free. First, Sheffey shoves a deputy out of the way and begins running. With deputies in hot pursuit, Sheffey sprints down a long hallway as this onlooker watches the activity. Sheffey makes it to the front steps. But as he leaves the building, another deputy, who was alerted about the escape, arrives shouting at Sheffey to stop. Sheffey ignores the order. That's when the officer fires his taser, sending Sheffey crashing to the pavement. Other deputies arrive as Sheffey's put in cuffs and flown to a West Virginia hospital for treatment. He suffered a head injury from the fall, but fully recovered after spending about a week in the hospital. Sheffey was then charged with flight to avoid apprehension, resisting arrest, and disorderly conduct, released on $20,000 bond. As for his initial charges and his DUI, those are pending. Next, we go to Centerville, Michigan for a sentencing. 59-year-old Edwin Smith has pled guilty to failing to stop at the scene of an accident, causing personal injury. 8 months earlier, Smith was behind the wheel of his car in a parking lot when he drove into his co-worker, Kimberly Van. Smith fled the scene, while Van sustained several injuries to her back, neck, and legs that required surgery. Smith was soon arrested and charged. Today, he appears along with his attorney, Luke Knopsinger, before Judge Jeffrey Middleton to hear his sentence. Smith could be facing up to 93 days in jail.
Mr. Smith, what would you like to tell me?
I'd just like to apologize to Miss Van for the whole deal. Truly sorry.
Just a minute.
Happened.
Just a minute. I heard a big you.
That obscenity came from the victim, Kimberly Van, who's just off camera in the gallery.
I expect you to be respectful in here. And if I hear it again, you're going to be found in contempt and you're going to go into custody. Do you understand? Do you understand?
Yeah.
All right. Go ahead.
I would just like to apologize for all of it. Truly never meant for it to happen.
Miss Van, if you think you can keep it together, do you want to speak to me? Please come forward.
Van comes forward to make a statement to the court.
Sorry for cussing, but I do not believe that his apology.
Well, what would you like me to know?
I am asking the court to hold him at the max jail time that is possible. He should go to jail and lose everything like I have. I have now been fired because I was unable to return to work after surgery. I still have pain. Please do not be lenient when you go to sentence him today.
Do you believe he ran over you on purpose?
I believe he ran over me on purpose because he was drinking.
If he was drinking, there certainly isn't enough evidence to charge any drinking driving.
I wasn't drinking that day.
According to police, there's no evidence that Smith had consumed any alcohol on the day of the incident.
I do not believe he intentionally ran over you in the parking lot. You want him to go to jail for the maximum amount of time. You want him to lose his job. None of that is going to fix your injuries. I am sorry that you lost your job.
But I wouldn't have lost my job if I wouldn't have gotten hit by a car.
All right, so you want to tell me something else?
Just go ahead.
Judge Middleton moves on to the sentence.
I am going to do a 12-month probation. And he isn't going to use any alcohol or any controlled
So
substance.
he's not even going to jail for this?
Stop.
I'm just asking a question.
I'm doing the sentencing. Stop. I'm going to order 10 days jail to be served either on weekends or work release. I'm not going to make you lose your job.
10 days.
A frustrated Van heads for the exit.
Go get her. Please come up and have a seat.
Whatever you want.
All right, you want to curse at me a little more? Is there anything else you have to say? All right, you should just go now.
Van exits the courtroom for the second time, but again is unable to hold back her emotion.
All right, come here.
The deputy rushes out to retrieve Van.
I find that you're in contempt of court and you're going to jail for 24 hours. Effective right now. Yes, really. You did this to yourself. You're going to jail for 24 hours for your continuing disrespect. I gave you a chance to just leave and then take her out of here. Yes. All right, I'm sorry. I took it as far as I could take it.
Later that day, Van's attorney filed a motion asking the court to reconsider the contempt order. Van was released, and the request is pending. As for Smith, he was sentenced to 10 days jail plus 2 years of probation.
We now head to Stillwater, Oklahoma, for a lesser-known aspect of the legal system that we rarely touch here on Court Cam.
the potentially dangerous business of bail bonds. Seated behind the desk of signature bail bonds is owner 41-year-old Chastity Carey. A week earlier, she was hired by this man, Brandon Williams. Carey paid his $35,000 bond so he could be released while waiting to return to court to face charges of second-degree burglary and possession of marijuana. The third person in the office is Chastity Carey's 19-year-old son and the butt of Williams' jokes.
You got out of jail? No, you're a boy, ain't you? Just got out of jail. Ouch. I ain't gonna lie, bro. I hit on your mom nonstop. Well, no, I don't.
But this is no laughing matter. Williams is unaware that Carey and her son are planning to revoke his bond and take him into custody after they learned he was planning on leaving the state for a trip to Florida to attend his mother's funeral.
What? Turn around. What do you mean? Turn around. What's going on here?
I'm going to sit and talk to the cups. We're going to chat. Turn around.
Well, I'm not getting no cups.
Yeah, actually you are.
For what?
Meeting on the way over, you can turn around.
Williams quickly realizes Carey isn't playing around.
Turn around.
Open the door.
No,
Hey,
turn around.
don't put your hands on me.
Turn around, put your hands behind your back.
Don't put your hands
Turn
on
around
me.
and put your hands behind your
Why? What are you doing this to me for? Why are you doing this?
back. Sit down. Hands behind your
What are you doing this to me for, man? Wow.
Holy
Mom, you just shot him.
I did. Call PD.
Mom, oh my God.
911. 911.
Mom, you.
After Williams is blocked from leaving through the door,
Why are you doing this?
he tries climbing out a window just off camera and onto a balcony below. That's when Carey grabs a loaded handgun from her desk and fires a single shot, striking Williams in the lower back.
Mom, you just shot him.
I did. Call PD.
Mom, oh my God.
911. 911.
Mom, you.
Police and paramedics arrive shortly after, but Williams is pronounced dead at the scene. In the police interviews that followed, Carey claimed she was acting in self-defense and that Williams had attempted to take the gun away from her right before she pulled the trigger. The video, however, appeared to tell a different story. Carey was later arrested and charged with first-degree murder. Cameras were not allowed in the courtroom during the 4-day murder trial, but the surveillance video would be a key piece of evidence for both the prosecution and the defense. The state argued Carey was not acting in self-defense because the video showed Williams trying to get away from her when she shot him in the back. The defense, however, said, quote, "What's not on the video is the reasonable doubt." And what that means is to convict Carey of first-degree murder, jurors would need to believe that she deliberately intended to kill Williams. Ultimately, the jurors decided the state's case did not meet that burden of proof. Carey was found not guilty of first-degree murder. The victim's ex-wife has since filed a civil lawsuit against Carey. We go to Chattanooga, Tennessee. We're inside the Hamilton County Courthouse, and that's Donald Trivett. He just entered the building, but he has no court business to attend to. So why is he there? He wants access to an office so he can take a shower. When told he doesn't have an office there, Trivett doesn't take the news well. Three deputies try to restrain Trivett, who sends one of them to the floor. Finally, he's taken down, and deputies appear to have things under control. But look closely. You can see Trivett reaching for the deputy's holster. If he grabs the gun, this scuffle could turn deadly. But there. A quick-thinking bailiff releases the magazine from the weapon. Even against 3 men, Trivett continues to fight. By now, a dozen officers have arrived on the scene. As a precaution to prevent officers from being bitten, a hood is placed over Trivett's head, and he's taken away in handcuffs. Trivett's charged with aggravated assault, reckless endangerment, and resisting arrest. No officers were seriously injured during the incident.
It's coming back in. Oh boy. It's gonna be that day.
We go to Ann Arbor, Michigan for a preliminary hearing. 34-year-old Stephen Ruggs has been charged with assault and domestic violence. 2 months earlier, Ruggs was arrested and then released on $5,000 bond under the conditions that he undergo regular drug testing and not have any contact with the alleged victim. This is Ruggs' second domestic violence charge in the last 7 months. The previous case was dismissed. Today, Ruggs appears before Judge Cedric Simpson to discuss next steps in the case. He's represented by attorney Silvana Reed. The prosecutor's Nicole Hughes. Before the hearing begins, Hughes wants to discuss a recent drug test that Ruggs missed.
Yeah.
The May 17th bond violation report.
I do. Is there a reason why you were missing? You were testing elsewhere, weren't you?
No, sir.
If I give you a test today, are you going to test?
Yeah, the only thing I'm going to fail for would be marijuana.
Why are you using that?
Can I speak freely?
Yes.
Your Honor, I'm going to be upfront honest with you. I used to have a crack cocaine addiction, and I've come a long way. I've been through a lot, this past few months. I lost my father, my grandmother. Just no excuses.
Give me an order. Okay, he's going to go over to community corrections test today. I'll get the results, and then I'll determine what his bond will be as he proceeds up, because he's told me what's going to happen, and then we'll figure out what we're going to do.
As the defendant exits the courtroom, something gets the attention of the prosecutor.
Yeah? Okay. What was that on? It's coming back in. Oh boy. It's gonna be that day.
Ruggs and both attorneys return to the courtroom.
What's wrong?
I just bring surprises.
Yeah.
Is that file still in the courtroom?
It's sitting here right with me.
As we were leaving, the deputy let me know that the victim was actually present today with the defendant sitting beside him. As we exited into the hallway so that I could see who the deputy was referring to, the defendant was speaking to is out in the hallway. And the deputy confirmed that that is the victim. With that, in addition to the community corrections violation, I'm requesting that he be remanded and that its bond be revoked.
Your Honor, I have no further information at this time.
Does he admit to the violation?
Your Honor, not speak.
If you wish.
She wasn't here with me today, Your Honor.
Were you talking to her in the hallway?
She made a comment to her in the hallway.
Judge Simpson isn't convinced.
Were you sitting next to each other in the courtroom?
Courtroom video from earlier in the day shows the defendant and the alleged victim sitting together in the back of the gallery.
You know I can get video from the courtroom.
Yeah, she was sitting next to me.
You're not to have contact with her. You know that. Forget the testing. Defendant's bond at this time is revoked. Defendant's remanded.
Thank you.
Your Honor.
Ruggs was taken into custody and remains in jail. His case was bound over to circuit court and is pending.
We go to the Veterans Memorial Courthouse in Lansing, Michigan. for the trial of 35-year-old Joshua Harding, who's been charged with 2 counts of sexual assault. There's Harding. 2 prosecutors represent the state, including Jonathan Roth, who, prior to sentencing, asked the court to consider a sentence on the higher end of the guidelines. At the far end of the table is Detective Brian Kanan, the lead investigator in the case against Harding. The jury's reached a decision in one of the cases and is about to read its verdict. In under 8 seconds, so much has happened. Let's look at it again. If you look a little closer, you can see Harding remove something from inside his sleeve. Turns out Harding is holding a metal shank. Harding storms the prosecutor's table, headed straight for Assistant DA Roth. If not for the quick reflexes of Detective Kanan, Roth could have sustained serious injuries. 2 court deputies immediately take action to help bring Harding, who stands 6'6" and weighs 280, to the ground. Watch as Roth removes his glasses to take a step towards the scrum. A spectator points something out to Roth. It's the shank. Meanwhile, Kanan and the 2 bailiffs are still wrestling with Harding. It took about 30 seconds to eventually cuff and remove the defendant from the courtroom. This brazen attack brought Harding an additional charge of assault with intent to murder, to which he pled guilty. As for the original charges, Harding was found guilty of second-degree criminal sexual conduct and is now serving a combined sentence of 44 years at a state prison. The earliest he could be released is the year 2064. Authorities are unsure how Harding got the weapon into the courthouse. Because Harding was in police custody during the trial, he did not have to pass through a metal detector upon entering the courthouse. He also was not required to wear handcuffs.
We head to San Antonio, Texas for a sentencing hearing. 21-year-old Michael Montoya has pled guilty to murder. A year earlier, Montoya and his stepfather, 40-year-old Edward Charles, were on a construction job with their supervisor, 58-year-old Paul Butler. That evening, without any known motive, Montoya approached Butler and shot him multiple times in the back and head, killing him instantly. Montoya fled the scene, but later returned and surrendered to police. He pled guilty, but offered no explanation for the shooting. The gun used in the shooting was legal and registered to Montoya. Today, he appears before Judge Stephanie Boyd to enter his plea and hear his sentence. But first, defense attorney Matthew Allen asks Michelle Hernandez, Montoya's mother, to speak about her son's upbringing.
Did he witness alcohol abuse?
Yes.
Did he witness people using drugs?
Yes.
And around the time of this incident, on that day, do you know if Michael had used drugs?
Yes.
If you know, what did he use?
Marijuana and methamphetamine.
Next, prosecutor Jason Garahan has a few of his own questions.
And you're not aware of your son's drug use, is that right? The extent of it, that's what.
Not the extent of it, no.
Okay. So you used methamphetamine with him that same day?
Were you using meth with your son? That's either yes or no.
Yes.
All right, thank you.
The prosecutor then has a few questions for Edward Charles, Montoya's stepdad, who's also testifying for the defense.
You're aware of his drug use, though?
Yes.
I mean, that night, you smoked marijuana.
Yes, I did smoke marijuana.
Finally, the state and defense make their sentence recommendations.
Michael is a 21-year-old with very limited history of any crimes. He was a normal young person, and then things outside of his control unfortunately influenced him in such a way that partly led us here today. But he's very remorseful. He's very sorry for what he did. We ask the court to take that into consideration and sentence Michael to 15 years.
The state strongly disagrees with the defense.
The day of, he smoked marijuana with his mom's boyfriend. The day of, he just chose to do methamphetamine. That caused him to be voluntarily intoxicated, that he chose that path. So a sentence of 15 years is not appropriate in this case. 35 years is appropriate because this person chose to go down the path he chose. But there's many people sitting in this courtroom today that chose different paths. And some of them are on a rocky road, but the fact is they haven't murdered somebody and shot them in the head.
After hearing from all parties, Judge Boyd makes her decision.
Mr. Montoya, do you deserve an apology? Yes. And you know why you deserve an apology? Because you had horrible parents in your life. Your mom, horrible parent, still a horrible parent to this day, using meth with you. She was horrible for bringing someone into your life as a stepfather, using drugs with you. So you have horrible parents, horrible adults in your life. When I sentence you today, I want you to know that I realize your childhood was horrible. And sometimes people have a childhood that's horrible and they make it out. And then sometimes when children are taken from the hospital to be with their horrible parents, you know that they're going to have a horrible life. But by that same token, there's somebody who's dead, who had family who loved and cared about him. And whenever a life is taken, society suffers because whatever they were bringing to this world, maybe for the benefit of others, we no longer have that. So I'm going to find you guilty. I'm going to sentence you to 35 years in the prison. Give you credit for any time served. All right, good luck to you.
Montoya was sentenced to 35 years in prison. He must serve half that sentence before he's eligible for parole. The earliest he could be released is 2040, when he'd be 38 years old. We go to Akron, Ohio for a sentencing. 34-year-old William Mozingo has pled guilty to kidnapping, abduction, felonious assault, and strangulation. 1 year earlier, a woman called 911 reporting that Mozingo, a friend of her husband's who had permission to stay in their garage, was not alone.
My husband went to go in our garage, and that friend is in our garage right now. There's a female with him. Her face is pretty beat up.
The injured woman was 23-year-old Chloe Jones, an acquaintance of Mozingo's, who police say he'd promised a place to stay. Instead, Mozingo, who was already wanted by police after recently escaping from jail while serving time for a drug conviction, held Chloe against her will for 4 days, beat her with a bat, and poured gasoline on her.
Hold on.
When officers responded to the 911 call, the homeowner directed them to the garage.
You know he's in there for a fact?
I know for a fact.
William, this is Akron Police Department. Come out now with your hands up.
When Mozingo refused to surrender, police broke in through this side door.
Come out now with your hands up.
Get out here now!
Come out now.
Watch your step.
Eventually, Mozingo complied and was taken into custody.
Come on, man.
In an attic space above the garage, officers found Chloe. She'd sustained multiple injuries, but was able to climb down.
No one else up there?
Chloe was taken to a hospital where she was treated for a broken nose, a broken hand, and multiple bruises. Mozingo, whose past criminal record included multiple convictions for abduction, was denied bond and initially pled not guilty.
We're on the record, State of Ohio versus William Mozingo Jr.
But today, as Mozingo's trial is about to begin, his attorney tells Judge Susan Baker Ross that the defendant has changed his mind.
My client has decided to enter a plea of guilty. Part of that reason is he does not wish to have the victim go through testifying.
Later that day, Mozingo returns to court to hear his sentence. But first, a victim advocate reads a written statement from Chloe.
A year ago, I was homeless and I came to you because you promised me shelter and safety. But that isn't what happened. What happened to me over the course of those 4 days has changed me forever. Because of you, I have a traumatic brain injury that I will forever suffer the effects of. Because of you, I battle anxiety and PTSD. But after this day, you will go to prison and I will go back to my family and those who love me. I will continue to grow and live and heal despite what you've done. Your Honor, he has done these horrendous things before and he will do it again. I don't ever want him to have the opportunity to hurt another person. He needs to go to prison for as long as possible.
Next to speak is Chloe's mother, Jessie Barham.
This is not the first time that you have abducted a woman, held her captive, and tortured her. This is actually the 4th time that you will be convicted of abducting a woman, holding her captive, and torturing her. Your Honor, all I ask is that you do what all the other courts and all the other judges before you did not do. And you are within the law. Put him away until he is no longer a danger to anyone, until he is feeble, until he is wetting his diapers. You don't scare me, William.
When she's finished, Mozingo delivers a statement to the court.
I would just like to say that this incident stems whenever we was both fueled up on methamphetamine. I've had a lot of time to think about it and reflect, and just at this time I'd just like to apologize to the victim and their family.
The judge sentenced Mozingo to 25 to 31 and a half years in prison. The earliest he'll be eligible for parole is in 2048, when he'll be 59 years old. Next, we head to Eureka, Kansas for a preliminary hearing. 33-year-old Bailey Cargile has been charged with aggravated battery on a law enforcement officer, fleeing an officer, possession of opiates, driving under the influence, and other charges. A month earlier, Cargile was driving with her boyfriend when police say they attempted to pull her over for driving recklessly. Police say that's when Cargile slammed on her brakes, causing the officer to rear-end her vehicle. Then officers say she got out of the car and fled the scene. But after a brief foot chase, Cargile was apprehended. Inside the vehicle, police say they found cocaine and methamphetamine. Cargile and her boyfriend, 25-year-old Owen Solomon, were both arrested. Solomon, who was hit with 4 drug-related charges, was released on $12,500 bond, while Cargile was held on a $45,000 bond. Today, Cargile appears from the county jail before Judge Phillips Webster to discuss next steps in the case. Solomon is also on the call for his case. The county prosecutor is Jill Gillette. Cargile's represented by attorney Richard Paul.
Mr. Paul, you said you wanted to be heard on bond?
Yes, Your Honor. Right now, she's being held on a $45,000 bond. We would ask for a $25,000 cash or surety bond. Judge, also, there's a no contact order with her boyfriend. They've been together 5 years, and I would ask that the no contact order be lifted as well.
Ms. Gillette, what do you have to say about this request?
Judge, she had 4 failures to appear on her record and has run twice. So I think $40,000 cash surety is appropriate for the charges.
Judge Webster has heard enough and is ready to make a ruling.
I appreciate your efforts on behalf of your client, counsel, but the modification request is denied at this time.
Including the no contact order, Judge?
Yes.
Okay, thank you.
Before Cargile returns to jail, she makes a subtle gesture towards the camera.
Who are you telling you you love?
And the judge takes notice.
Did she just violate the court's order of no contact? Sit back down.
It appears Cargile mouthed, "I love you," twice. Perhaps in the direction of her boyfriend.
Who were you just mouthing "I love you" to?
No, I was just saying that I'm about ready to go.
No.
Like, I'm about done.
Ma'am, I can replay the tape. You
Okay.
said, "I love you." Who are you speaking to?
I love my lawyer.
Who do you love? Who did you?
My lawyer, like for having my back today.
No, come on.
Like I like him.
Okay, so you love your attorney, you like
yes,
your attorney, and you are mouthing to your attorney, to Mr. Paul, "I love you."
I was actually saying it to the guard as I got up.
You were saying it towards the camera as you got up.
I was like,
okay, stop, Mr. Lennon. Is the co-defendant on here?
Judge, he's on here.
All right. Is Owen Solomon your boyfriend of 5 years?
Yes, Your Honor, he is.
And you didn't know he was on here?
I can't see. There's a lot of different people up on the screen, and you were the big one.
Okay.
I was literally talking to the CO.
No, I don't buy that. You were looking at the screen. Your mouthing was very clear. See, this is why I can't trust you to have a bond modification. You just burnt some serious bridges on credibility with the court, because you just showed me you don't have respect for the court. You don't have respect for your attorney, even though you claim he's the one you love. In any event, go ahead and leave. Go with the jail now. And just
thank you, Your Honor.
All right.
Cargile was later released on her $45,000 bond and has yet to enter a plea. If found guilty, she's facing up to 33 years in prison. As for Solomon, he was charged with possession of narcotics, possession with intent to use drug paraphernalia, and other drug-related charges. If found guilty, he's facing up to 11.5 years in prison. Both Cargile and Solomon's cases are pending. Next, we're in Ann Arbor, Michigan for a sentencing. 61-year-old James Forton has pled guilty to operating while intoxicated, a misdemeanor. 3 months earlier, Forton was drunk and high on opioids when he crashed into a vehicle, injuring the driver, 22-year-old Heather Dufek. Heather suffered a head injury and damage to her eyesight. Forton was initially charged with a more serious crime of operating while intoxicated, causing serious injury. If found guilty at trial, he could have been sentenced to 5 years in prison. But the state offered him a deal, and he pled guilty to the lesser misdemeanor charge. Now he's looking at a sentence ranging from probation to 180 days in jail.
Number 18, People versus James Forton.
Today, Forton appears virtually before Judge Patrick Conlon, who will decide on his sentence. But first, Heather makes a victim impact statement to the court.
Good afternoon, Your Honor. This past 16 months haven't been easy. The constant doctor's appointments, physical therapy, speech and eye therapy, plus going to a therapist for my PTSD, and so much more. I rely on my family for my care with my animals and my daily living. My mom and dad take me to all of my appointments at this time, as I am unable to drive due to my vision issue. Mr. Forton, you have changed my life forever.
Heather's words seem to have an effect on the defendant.
You have caused something I wouldn't have imagined of living in as a 22-year-old. And I hope you live with that guilt daily and know I deal with your pain on a daily basis because of your careless actions. Thank you, Your Honor.
Thank you, Ms. Dufek.
The judge then checks in with defense attorney Matt Savage.
I've gotten to know Mr. Forton quite well, and he was sober for almost 20 years. And due to a serious back injury, he was placed on
opiates to relieve him of that pain. And sadly, he cares for his wife, who is wheelchair bound. So he understands suffering. So he feels very horrible about what happened. He's been in counseling. He's been doing AA. And he's doing what he needs to do to make sure that this type of behavior doesn't happen again. For those reasons, Judge, I respectfully ask the court to consider the recommendation that probation has put forth.
When he's finished, Forton delivers a brief apology.
I'm truly sorry for everything. I'm doing my best, and I'm going to continue to stay sober. I never want to ever go through this again and hurt someone. It's inexcusable, and I'm sorry.
Before imposing sentence, Judge Conlon has a few words for the defendant.
I want you to know that the goal of this is to keep you sober and to have you never come back to court again. We want to make sure that not only is this a turning point for you, so that this doesn't happen again for the rest of us. Get off the opiates, stay sober, and keep the rest of us safe. That's the best we can hope for. So our hopes are on you, okay?
Thank you, Your Honor.
The judge sentenced Forton to 2 years probation. He must also pay Heather restitution of $4,363, attend AA counseling, and wear a tether that monitors alcohol consumption for the duration of his probation. We head to Orangeburg, South Carolina for a sentencing hearing. 22-year-old Lindy Lamont Jones has pled guilty to murder and possession of a weapon during a violent crime. 3 years earlier, Jones shot and killed 18-year-old Willie Fields Jr., a friend of his younger brother, Jalen. Willie had just arrived at the Jones home when Lindy Jones shot him 4 times as he sat in his car. Then Jones and his younger brother dumped the body in a nearby wooded area. When Willie didn't come home that night, his mother used a tracking app to locate his phone. It pinged at the Jones residence, and then again at the street where Willie's car was found. The next morning, police discovered Willie's body in the wooded area, just 700 feet from the Jones home. Lindy Jones was arrested and charged with murder. His brother, Jalen, a minor at the time of the shooting, was charged with being an accessory after the fact. At first, Lindy Jones claimed he shot Willie because he was trespassing. Then he said it was because Willie was reaching for something, but eventually he accepted responsibility and pled guilty to all charges. Today, Lindy Jones appears for sentencing before Judge Roger Young. But first, Willie's mother, Angela Fields, prepares to deliver a victim impact statement to the court. By her side is Willie Fields Sr., her husband, and the victim's father.
Your Honor, I just want to let you know just what they took from me. They took away my only child.
As she speaks, with Jones standing just a few feet away, it apparently becomes too much for Willie Sr. to take.
It's been so hard.
Willie Sr. charges past a deputy toward the defendant. The victim's father lands a few punches before deputies rush over to pull him away. Jones lunges at Willie Sr., but he's quickly diverted by the deputies. Both Willie Sr. and Jones are removed from the courtroom and orders eventually restored. As for Lindy Jones, he was eventually sentenced to 35 years in a state prison. His brother Jalen pled guilty to being an accessory after the fact and was sentenced to 6 years in a youth offender facility. Next, we go to Houston, Texas for a hearing. 38-year-old Rolando Areola has been charged with criminal trespass. A week earlier, Areola was arrested for trespassing at a gas station convenience store. He'd previously been ordered by the court multiple times to stay away from the business. Today, Areola, who's being held in jail on a $5,000 bond, appears before Judge David Fleischer to discuss next steps in the case.
You have terrorized the people at the Chevron for the last 3 years. I've told you time after time after time not to go back to the Chevron. Yet you persist and you go back. I've ordered you not to go back repeatedly. Yet the minute you get out, you go back to the property over and over. So what can I do to ensure that you're not gonna go back? If you were in my shoes, what would you do?
You've asked me.
Yes.
That must have been
I've
court
asked
order.
you, I've ordered, I've prayed, I've done smoke signals.
These people know who I am. They allow me to go to the back of the store.
If you want, I will call them right now to see if you're allowed to go back.
I'm telling you this. I will not go back to that store.
And you done told me that before 18 times. Get the phone number.
At Judge Fleischer's request, State's Attorney John Kim speaks with the store owners and reports back to the courtroom.
The complainant stated that the defendant has previously come in with a stick and another time with a crowbar. The complainant is fearful for his safety. All 4 employees stated that they do not want the defendant at the gas station.
That is from the mouth of the people that work at that gas station.
This is the first time that I've heard that. It's troubling. I'm troubled from what I've just heard right now.
Don't go back. They're scared of you, Mr. Areola. They are scared.
Believe me, yes. Now that this statement was made, believe me. Okay, I have a family to take care of, and my time is being taken away from me being able to provide for my family. I promise you today, right now, that I will not go back to that. I'm telling you right now, because this is troubling. I promise you this court, I will not go back to that store.
After 2 more days in jail, Areola is brought back before Judge Fleischer to enter his plea. But first, the judge wants to make another call to the store owner.
We spoke previously about Rolando Areola. Is he allowed into that Chevron?
No, sir. I've given him multiple chances, and it's better to keep him off the property.
He's telling you he don't want you there. This is Judge Fleischer, and I'm trying everything in our power to make sure that Mr. Areola doesn't go back. And yes, we are going to release him, but I want you to let me know if he goes back, okay? Don't go back. You understand?
Areola pleads guilty, and the judge elects to give him a shot at probation.
Are you going to be able to complete this?
I will.
Okay. We shall see. I really hope so. If you go back, I swear I'm going to explode from anger. Do you understand, Mr. Areola? Okay. Good luck.
The judge sentenced Areola to 180 days in jail, which was suspended in lieu of 2 years probation. Areola must also take a class called Thinking for a Change in order to learn how to make better decisions. Since his release, he has not returned to the property. But 2 months later, Areola violated his probation when he was arrested in another county for assaulting a peace officer. That case is pending.
The drugs were there. I did not put the narcotics there.
We head to Jackson County, Florida, for the trial of Zachary Wester. The former sheriff's deputy was charged with 67 counts of racketeering, fabricating evidence, false imprisonment, and possession of controlled substances. Wester's accused of planting drugs in a dozen vehicles during random traffic stops.
A substance that appears to be an illegal narcotic. Do you know anything about that? I do not.
All of the drivers denied owning the drugs, but yet most were subsequently arrested.
You have the right to remain silent.
The arrest caused suspicion internally, and in 2018, Wester was suspended. 3 years later, the case went to trial. He pleaded not guilty to all charges.
This is a case about an abuse of an incredible power, about the abuse of the incredible trust that we all put, and we have to put, in law enforcement in a society.
The prosecution relied on the defendant's own body cam footage to help argue their case. Stephen Van, a convicted felon, had recently gotten out of jail when Wester supposedly found methamphetamine in his car.
Have you ever seen this before? No, what is that? I'm just trying to figure out how that stuff got in your car. You're gonna go to jail today for possession of methamphetamine, okay? Oh man, dude, I'm serious, dude. Anything, what you want me to do, man?
Like the other drivers who testified, Van gave the officer permission to search his car because he claims he had nothing to hide.
And I knew my truck was clean. I knew it was.
While the jury got to watch most of the traffic stops, some recordings had mysteriously disappeared.
Why in the world would that have been deleted? I wish I knew that answer.
Ironically, body cam footage would become the strongest element in the prosecution's case, especially when it came to Teresa Odom.
Hi, how are you?
I'm good.
At first, the officer's polite, even playful.
Anything in the vehicle I need to be concerned about? Bombs, hand grenades, rocket launchers? Okay.
While Odom stands behind the vehicle, Wester begins his search. Notice as he prepares to put his gloves on, there's a small item in his left hand. Prosecutors argue that Wester is palming a small bag of meth, which he claims to find next to a spoon in the vehicle.
Miss Odom.
It is yogurt, sir.
I know. Okay.
It's yogurt.
How about this, though?
That is not mine. No, sir.
Okay.
Now, the white small plastic baggie that was in that spoon that the deputy just showed you on this video, had you ever seen that before?
No, sir.
Was that in your car?
No, sir.
As far as motive, the prosecution claims the 28-year-old officer was ambitious and wanted to move to narcotics as quickly as possible. Wester testified he never planted any drugs.
The drugs were there. I did not put the narcotics there.
And after 5 days and several witnesses, the jury was asked to render a verdict. If Wester's found guilty on all charges, he could spend the rest of his life behind bars. After 7 hours, the jury returns with its verdict.
In the state of Florida versus Zachary Tyler Wester, we, the jury, find as follows as to the counts charged and the information. Count 1, guilty of racketeering as charged.
The clerk went on to read the verdicts on all 67 charges.
Count 7, guilty of official misconduct as charged.
In total, the crooked officer was found guilty on 19 charges.
Count 9, guilty of official misconduct as charged. Count 10, guilty of official misconduct as charged.
Including misconduct in the arrests of Van and Teresa Odom. 11 of the 12 drivers filed civil lawsuits against Wester. In July 2021, he was sentenced to 12.5 years in a state prison. We're in Dubuque, Iowa for a sentencing. 29-year-old Tyler Daisy has been convicted of first-degree murder and animal abuse. 8 months earlier, Daisy was living with his mother, 46-year-old Jennifer Daisy, and her dog, Echo. One morning, seemingly without provocation, police say Daisy attacked his mother with a hatchet, killing her. Daisy also killed Echo, the dog, who died from a significant blow to the head. Afterwards, Daisy returned to his bedroom, and Jennifer's friend, Christy Folman, arrived at the home, discovering the bloody scene. She called 911, and when police arrived, they discovered Daisy naked in his bedroom and took him into custody. Daisy later told police he killed his mother because he believed she was practicing witchcraft. He was charged with murder and animal abuse and pled not guilty. After prosecutors and the defense requested psychological evaluations, a judge ruled Daisy competent to stand trial, where it took a jury just 2 hours to find him guilty. Today, he appears before Judge Thomas Bitter to hear his sentence. But first, members of the family deliver victim impact statements, beginning with Katie Tressel, the defendant's aunt and the victim's sister.
I hate that my sister, your mom, is gone. I hate that you must go away the rest of your life. I hate that my nephew is dead because you're not my nephew. I will always love you and remember the person I once knew, but I don't know you anymore. You are better out of society. Everyone will be safer without you.
Daisy's younger sister, the victim's daughter, also delivers a statement.
Tyler, how does it feel to lose your whole family due to one thing that you did? You can think you have God, but that's not a real God at all. I don't know what you have going on.
10 Commandments.
Okay.
Bear false witness, you killed brother.
Okay. Look at you. This is sad.
Mr. Daisy, let her speak. Let her finish.
I hope you enjoy life in prison.
I can live forever. I have God. Where's your God?
That's
Jesus?
great God.
Let's see Jesus save you.
Mm-hmm. I'm glad you're getting
finish what you want to say.
I enjoy that. At least you have some type of feeling.
Read the Bible.
I'm done.
Okay, thank you.
When she's finished, Judge Bitter checks in with the defendant.
Mr. Daisy, is there anything you would like to say today?
No, I have no idea what you are asking of me to say, other than thank you, Your Honor.
Okay, thank you, sir.
And with that, the judge sentenced Daisy to life in prison. For killing Echo, he received an additional 2 years, which will run consecutively. He'll have no chance of parole. Next, we're in Detroit, Michigan for a sentencing hearing. 31-year-old Mita Macaggle has pled guilty to assault and battery. 2 years earlier, according to police, Macaggle assaulted a bar patron who was out with Macaggle's ex. The victim didn't suffer any serious injuries, and Macaggle was eventually arrested and charged. Today, she appears before Judge Elenice Bryant to hear her sentence. But as the judge waits to begin the hearing, Macaggle seems to be having some technical issues.
Mr. Macaggle, I need you to start your camera. I'm trying to turn my camera on. Oh, Miss Macaggle. Yes, I'm sorry.
When Macaggle finally appears, the judge is not happy with what she sees.
Ma'am, you coming to court with facial cream on your face? That's inappropriate. Ma'am, okay, I'm sorry. No, listen to me. It's inappropriate and it's disrespectful for you to come on this Zoom with that face cream on the day of your sentencing. This is not a game. It's not a joke. We come to court professionally attired, and that is absolutely disrespectful. Now, please go wash your face and come back prepared for court. I'll bring you back out when I'm ready in a minute when she wash her face.
Several minutes later, after the defendant removes her facial cream, Judge Bryant continues the hearing.
With respect to sentencing, is there anything on behalf of the people?
No, thank you, Your Honor.
Anything on behalf of the defense?
Judge, I just asked that the court follow the plea agreement that was entered into between the prosecutor's office and us.
And what is that agreement?
Judge, that agreement was for 9 months reporting probation, mandatory drug evaluation, and no contact with the victim.
That's correct.
Ms. Macaggle, do you want to make a statement on your own behalf?
So the drug evaluation, will I have to
I didn't say ask me any questions. I said, do you want to make a statement on your own behalf?
No, I guess not.
There is a recommendation for a probationary period of 9 months. The court will accept that and sentence Ms. Macaggle to a term of probation for 9 months. Additionally, ma'am, you shall not use or possess any illegal substance. Attend and complete 12 weeks of anger management. Ma'am, what you doing?
Nothing, just moving to another room.
Right, why? Because I'm in the middle of your sentencing.
I know, I hear you. I'm listening. I was just moving to another room.
Don't move to another room. Otherwise, we're going to come in person, and then we'll never have to move out of that courtroom.
Yes, ma'am.
Once Macaggle settles into her new seat, Judge Bryant wraps up the hearing and offers the defendant some final advice.
Ms. Macaggle, when you come on Zoom, we're in court. Don't ever show back up in my courtroom with face cream on your face or walking around. We're stationary, seated in an upright position, and ready to attend court at all times while we're in court. All right, we are all set. Everybody have a great day and stay safe.
Your Honor, never mind.
She laughed. And she got mad, but she gets mad at the All right. Have a great day. See you. Stay safe.
Macaggle was sentenced to 9 months probation, plus $282 in fines and court costs. Next, we go to Carlsbad, California for a sentencing. 42-year-old Julie Harper's been convicted of second-degree murder in the death of her husband, 39-year-old Jason Harper. 3.5 years earlier, Julie and Jason, a high school math teacher, were having an argument while their 3 young children were downstairs watching TV. According to Julie Harper, Jason charged at her, saying he was going to kill her. That's when Julie took out a loaded pistol and shot Jason in the side, killing him. She then covered Jason's body, and after disposing of the gun, took the children to her father's house 30 miles away. Later that evening, Julie Harper turned herself in, and the state charged her with murder. Just days before the shooting, Harper had filed for divorce and withdrawn $25,000 from the family bank account. She said that she shot Jason in self-defense, claiming he'd been abusive throughout their 10-year marriage. But investigators found no corroborating evidence of abuse, and aside from Harper's own testimony, none was presented at trial. When both sides came to rest, it took a jury 1 day to return with a verdict: guilty. Today at sentencing, Harper waits for Judge Blaine Bowman to hand down her punishment. But first, a number of family members come forward to share victim impact statements, beginning with a written statement from Jason and Julie's 12-year-old son, read by prosecutor Keith Watanabe.
Julie Harper has caused much pain and misery to all the members of the Harper family. She murdered with no sense of the consequences, as leaving my siblings and I parentless. She had destroyed our lives and now will not accept the consequences. She did not realize that eventually she would go to jail, and now she is trying to weasel out of punishment.
Next, the prosecutor reads a statement from the Harper's 10-year-old daughter.
I blame Julie Harper most definitely for the fact that my father is dead. Also, I want to say that I no longer have a mother because she was so selfish and self-centered. She wasn't thinking of caring about anyone except herself. Because you killed our dad, you are no longer Mom. You are Julie. I will never call you Mom again for what you did, and I don't want anyone else referring to you as our mom. You made my brothers and me orphans. I beg the court to give her the full prison time she deserves.
Before the judge imposes sentence, the defendant makes her own statement.
A, B, C, D. Another behind closed doors. My husband was a different man behind closed doors. But he was a very different man to me. And it has been so hard to go through all of this for the last 3.5+ years after what I went through with him for years and years. And I'm still recovering from everything he did to me all those years. It seems so inconceivable to me to be facing potentially 40 years to life in prison when my husband was the one that terrorized me.
When she's finished, it's Judge Bowman who has the last word.
I understand, Ms. Harper, that you feel that a 40-year to life sentence is unfair, but you have to understand that your husband got a death sentence. Your husband's never coming back. All right? Unfortunately, the court does not have the ability to fashion a sentence that would bring Mr. Harper back to life. If I could, I would, and that's what certainly the Harper family would like. That's what your kids would like. This shooting, in the opinion of the court and in the opinion of the jurors, was no accident, and you killed him just days after filing for divorce. You are no doubt a danger to society in the opinion of the court, and you are sentenced to 40 years to life in prison for the killing of Jason Harper.
Julie Harper's serving her 40-year sentence in a California correctional facility. She'll be eligible for parole in 2034, and she'll be 61 years old. The Harper children are currently living with Jason's parents.